looking forward to hearing both my fellow speakers today, but also I can see there are some wonderful colleagues in the audience, so looking forward to our discussion after presentations. So my brief today is to set the legal and policy scene in comparing the Danish and UK externalization arrangements, and I'll do so on the assumption that colleagues here today are broadly familiar with the UK-Rwanda APA, as I refer to it. So what I'll do first is briefly outline the Danish proposal, which is perhaps lesser known. I'll then draw out some similarities and differences between the two approaches before making some final reflections on our overarching question as to whether we are seeing a new era for Europe's anti-refugee policies. So firstly, to the Danish approach, as some of you would know, in June of 2021, the Danish Parliament passed a legislative amendment inserting a new paragraph into the Aliens Act, allowing for the transfer of asylum seekers to a third country outside the EU for the purposes of both asylum processing and subsequent protection of refugees in that third country. So this will be familiar to many of you. The Danish model essentially foresees three phases. The first phase is a pre-transfer phase by which asylum seekers arrive in Denmark. And this in legislation and explanatory memorandum is set out in most detail with the establishment of a two-instance individualized procedure to assess whether the asylum seeker can lawfully be transferred to the third country. The law proposal did not include in detail which asylum seekers would be exempted from transfer, but did give a few examples, including nationals from the third country itself, that is to say Rwandans, asylum seekers with family in Denmark, and seriously ill persons. Secondly, the law proposal provided that the full asylum procedure would take place in the third country, and that country would have ratified and in fact respect the 1951 Refugee Convention with access to a sound asylum procedure. However, the law proposal did not specify which safeguards would be in place for the asylum procedure, nor did it address the key question of potential discrepancies in interpretation between Danish refugee law on the one hand and the third country's national asylum framework. Moreover, the law proposal did not specify which government would be responsible for the asylum process. Indeed, the proposal was adopted on the basis that either Danish asylum authorities acting extraterritorially could run the asylum procedure, or indeed, like the UK-Rwanda agreement, it would be essentially a transfer agreement to the third country's asylum authorities. The third phase envisaged by the law proposal would seem to take an especially narrow position on the rights afforded to refugees in the third country. So the law proposal required that the third country be a party to the 51 Convention, but only set out the condition that the country must in practice respect the principle of non-refoulement. So that, to me at least, would seem to ignore the rather wide array of rights set out in Articles 2 to 34 of the Refugee Convention, including, of course, the right to primary education, the right to work, access to housing, freedom of movement, and the right to identity documents. So that, in a nutshell, is the Danish proposal. And now I'd like to move on to make some comparisons between the Danish model, which of course hasn't been implemented, and there is no agreement with Rwanda as yet, and the UK arrangement that we see potentially unfolding before our eyes. Firstly, of course, there are a number of striking similarities between the Danish and UK approaches. Both approaches, for example, seek to externalise responsibility for both the asylum procedure and refugee protection in the third state. To my mind, the term offshore processing, even though I've used it myself in the past, is somehow misleading because it places so much focus on the asylum procedure, whereas of course both these schemes are designed to externalise both asylum processes and subsequent refugee protection in the long term. Both approaches, of course, involve Rwanda specifically. So since the announcement of the UK arrangement, the Danish government has confirmed it is in concrete negotiations with Rwanda on a transfer agreement, which was widely thought to be the case, but not confirmed. And of course, such negotiations at the bilateral level build on an April 2021 agreement on asylum migration between Denmark and Rwanda. However, that agreement provided no basis for transfers from Denmark to Rwanda. Of course, we also see that both approaches have been linked to legislative change. So in the Danish case, what we see is the legislation predating any subsequent agreement, as I've just outlined. In the UK, in some contrast, we know that the APA applies to asylum seekers who arrive illegally or by dangerous methods from safe third countries in the UK after the 1st of January 2022. And this mechanism would seem to be based both on existing immigration rules in combination with Schedule 3 of the Nationality, Immigration and Asylum Act, and indeed is strengthened under Clause 30 of the newly passed Nationality and Borders Act, which has, of course, one of its objectives of enabling asylum claims to be processed in a third country. So that is to say that the Danish approach had legislation first and then an agreement subsequently, whereas the UK has sort of flipped the script. And finally, of course, in terms of similarities, both approaches are clearly deterrence focused. So while there is language around solutions, both governments have acknowledged that they're primarily interested in deterring further asylum arrivals rather than constructing a new refugee protection system. There are, though, I think, some notable differences between the two arrangements. Firstly, the Danish legislation applies in principle, at least, to all asylum seekers, irrespective of mode of arrival, while the UK, of course, is limited to irregular arrivals. So this would seem to build in, to my mind, a much higher discretion element on the UK side and raises questions immediately around discrimination as to who is selected for transfer. Denmark also has always foreseen a binding international agreement and not a political MOU. And it will be very interesting indeed to see if this position will change. The law proposal that I mentioned earlier foresees the conclusion of international agreement between Denmark and Rwanda, with the concrete agreement being tabled before the Danish Parliament before implementation. And finally, of course, a key difference is that Denmark is an EU member state. And while Denmark has key opt-outs from much of the EU asylum system, it is, by way of a parallel agreement, still part of Dublin cooperation. And this would seem to raise the potential risk of other EU member states no longer consider Denmark safe for return for asylum seekers if a Rwanda transfer mechanism is established. So to turn finally to our overarching question for this evening as to whether we're in a new era of European refugee policy, I would tend to see both the Danish and UK approaches on a sort of spectrum or continuum of previous attempts to delegate responsibility for asylum processing and or refugee protection to another state. And Vicky's mentioned, of course, the Australian approaches. I think equally the EU-Turkey statement is of inspiration here. And I'm equally interested in the asylum cooperation arrangement shortly in place between the Trump-era US and Guatemala authorities, which was, of course, rescinded by the Biden administration. So to my mind, these two approaches build on a fairly rich tapestry of externalization efforts. Of course, these new proposals also raise the question about whether we can consider what Jeff Crisp has called rights-based externalization, whether we can imagine transfer mechanisms that indeed both respect international human rights and refugee law and could be seen to indeed share responsibility for refugees. So clearly the UK and Danish schemes do not meet these criteria, but I think their push for innovation do raise the question about whether such approaches are possible. So to turn to whether these approaches represent a new day in European refugee policy, to my mind, both legal and policy elements would suggest that in the short term, this should be answered in the negative. Of course, the UK now operates entirely outside the EU asylum acquis, and while Denmark's opt-out from much of the acquis renders Denmark's approach legally possible where it would not be in other member states, I do not see a reform to the European asylum system in Europe allowing such aggressive externalization approaches. And here in particular, I'm thinking of current safe third country concepts, which require that there be a connection between the asylum seeker and the third state, the transfer, and that it would be reasonable to transfer that person to a particular country. I'll stop there. Thank you very much.
Thank you, Nick. That was a really helpful comparison between the UK and Denmark externalization agreements. Just a kind reminder to make sure that your mic's off if you're not speaking. Yeah, I agree with Peter. Very clear and helpful. We'll now move on to our second speaker, Dr. Nicola Palmer. Nicola is a reader in criminal law at King's College London. She has written extensively on the relationship between international criminal law and border control, resistance to mass violence and legal pluralism in Rwanda. Prior to her academic career, she worked at the UN International Criminal Tribunal for Rwanda. She'll be speaking today on refugees and border control in the Rwandan context. I'll pass over to you, Nikki.
Wonderful. Thank you, Vicky. And it's great to be here and to be having this discussion. So thanks for the opportunity and for facilitating such a wonderful group of people together. So Rwandan President Paul Kagame, in his first public address after the conclusion of the UK-Rwanda Asylum Agreement, directly connected these potential deportations to the Rwandan government's push for the extradition of 5 genocide suspects from here in the UK. So in his words, when talking to a group of diplomats in Kigali, he said, when the UK is sending us immigrants, they should send us some people they have accommodated for over 15 years who committed crimes in Rwanda. Now, the Home Office were quick to deny any link between the deal and the issues of extradition. And their spokesperson was quoted in The Guardian stating the following: any matters on extradition with Rwanda are not part of our immigration and economic development partnership, and to suggest otherwise would be completely wrong. This is an independent Metropolitan Police inquiry, and it would be inappropriate for us to comment further. Now, what this response from the Home Office belies is how Rwanda's transnational pursuit of genocide suspects has been deep entwined with European, North American, and UK border control. So for 15 years, the global pursuit of individuals suspected of involvement in the 1994 genocide against the Tutsi has led to Rwanda establishing a transnational network of cooperation among criminal justice and border control personnel in over 20 countries around the world, including the UK and Denmark. And as Nick indicated, the Danish government's existing diplomatic agreement with Rwanda on cooperation, asylum and migration issues, which, as he said, was signed in 2021, but offered very little detail, followed on from the extradition of 2 genocide suspects to Rwanda. And so it's really this transnational network of personnel and the web of legal decisions that have accompanied it that I want to suggest over the next few minutes can help us to explain why this particular deal has been reached with Rwanda. And so I'm going to speak briefly about how this network has been developed in order to try to understand the wider context of Rwanda's engagement with European carceral border control. But before I do this, I want to address the question of focus. So as Devani Prabhat and others have recently highlighted in these border criminology debate, the discussions that have been led on the Border Criminology's blog, as Vicky indicated, I really think that the first legal issue at the heart of the so-called Rwanda deal is found, although as Nick said, the deal preceded it, it is found in the new Nationalities and Border Act of 2022, which, among other things, as I'm sure all of you are familiar, the Act amends Part 4 of the Nationality, Immigration and Asylum Act, and it establishes that asylum claims can be deemed inadmissible if they are made by a person with a connection to a third state country, based, as Nick said, on the terms on which those individuals entered the UK. Now, if my reading of this is correct, the necessary connection now envisaged in the Act is essentially that the necessary connection to that third country is essentially that that country is deemed safe. Now, this establishes this two-tiered process in which some claims are admissible and some are not. And to me, this really underpins the externalization of the UK border control and must be the central focus of the challenges to it. It's discriminatory and it's against the spirit of the 1951 Refugee Convention. So in terms of focus, what I want to suggest here is that to move too quickly, both in academic discussions and in legal challenges against the UK Rwandan policies, towards determining whether or not Rwanda constitutes a third safe country is, in my view, to concede one of the major battles against this trend towards externalization. I think we need to be very conscious when talking here from the UK, how quickly and how comfortably the political debate and the legal gaze can turn from the harms caused by political decisions and policies made in the global north towards the harms committed in the global south by local actors, be they states or private individuals. So the UK High Commissioner on Refugees has been crystal clear that the externalization of states' international legal obligations undermines the cooperative principles on which the Refugee Convention is founded. There are over 34.4 million refugees and asylum seekers worldwide, and the vast majority of them, as I'm sure many of you on this call already know, are already hosted in countries neighboring their countries of origin. 86% are hosted in global south countries. And now the recent Rwandan experience with people claiming refugee and asylum protection coheres with this global picture. So as of August 2021, there were approximately 120,000 registered refugees in Rwanda, and 61% of these individuals came from the Democratic Republic of Congo in the wake of the violence in 1996, in 1998, and more recently in 2012 and 2014. And we hope with the current uncertainty in the Eastern DRC that that number does not rise. And then 38.6 are from Burundi, mostly in response to the 2015 political unrest. And then 0.2% are from Eritrea, and the other 0.2 are from another country. So Rwanda's experience in responding to refugee and asylum claims is actually a story of a southern country responding to refugee movements from its neighboring state. So how then did Rwanda become involved in a very different type of policy response to refugees? One that's about externalizing wealthy states' obligations to offer refuge. And I suppose this is where I feel that my contribution and my current work might be able to be part of the discussion. So rather than offering my assessment on whether Rwanda meets the threshold of being a third safe country, I want to look at how Rwanda became involved in the first place and what this shows us about the wider work of criminal law, including international criminal law in border control. So answering this question, I then think also helps to explain why Kagame immediately linked this agreement with the extradition or domestic prosecution of 5 genocide suspects who are living here in the UK. Since 2007, the Genocide Fugitive Tracking Unit, a special branch of the Rwandan National Public Prosecuting Authority, has been working with police forces, border control officers, and other prosecuting authorities around the world to investigate, extradite, or deport individual genocide suspects. 1,147 indictments have been issued by the Genocide Tracking Unit, and this has led to legal proceedings in over 20 countries. And it's resulted in at least 122 cases concerning 102 individuals, including the suspects here in the UK and the 2 individuals who have been extradited from Denmark. And so what I've been doing over the last few years has been developing and writing on a database of these proceedings. And overall, what I think this database shows is that the deportation of genocide suspects for immigration-related offences has been quicker better resourced and less scrutinized and more immediately in favor of sending people back to Rwanda than the extradition on genocide charges. So the Rwandan government, in other words, has long recognized that border control is setting the terms of global South-North engagements. And it provides the basis on which states, wealthy states, are willing to commit resources towards particular policies. Now, the initial policy objectives of the Rwandan government that has built these transnational penal networks has been underpinned by their pursuit of genocide suspects around the world. And this has done expressivist work that's important to the Rwandan government. So it's affirmed the universal wrong of genocide and the genocide against the Tutsi in Rwanda specifically, while at the same time extending the penal reach of the Rwandan state into diaspora communities that have and may continue to organize politically in opposition to the Rwandan government. But this expressivist work has also been important in the northern states in which these cases have been pursued. So the picture concerning the extradition of genocide suspects to Rwanda has been mixed, with the UK, France, Italy, Switzerland, and Finland refusing extradition, and Denmark, Sweden, the Netherlands, Germany, and the DRC allowing it. In contrast, the deportation and immigration-related proceedings have seen consistent removal of residency permits, withdrawal of citizenship, denial of asylum applications, or criminal prosecution for immigration offenses across all of these states, as well as in the US, Canada, and Uganda. So within my data set, 10 states have addressed suspect immigration status, and of 35 cases, 29 are found against the suspects. Now, in my paper that came out with the Leiden Journal of International Law in 2020, I helped to explain these differences in terms of thinking through some of the distinctions in the collective expressions of shared social values that distinguish extradition proceedings from immigration ones. So the extradition law is focused on a state's assessment of another state's criminal justice system. The norms being generated and asserted in these Rwandan cases relate to a state looking outwards towards another state's practice, often in this instance, a global north state assessing that of the global south. In contrast, immigration law, particularly in relation to refugee exclusion clauses and the removal of citizenship, expresses a state's view on the types of people considered deserving of citizenship or refugee protection. In other words, it's about looking inwards, asserting who does and does not belong. Now, and this is what I've been thinking about over the last few weeks, the current legal challenges to the UK-Rwanda deal are going to do a bit of both of this, but in a slightly different way. So to focus, as I suggested at the beginning, on whether the policy itself is discriminatory, focuses on the obligations on northern states, particularly wealthy ones, to offering the refugee protection. It's a question of what refugee protection means, and this is a hugely important fact. To focus on the view of whether Rwanda is safe or not, to move to that too quickly, concedes that the discrimination in the asylum processing is reasonable, and the debate turns to whether these obligations should be externalized to Rwanda or to somewhere else. Now, in my initial assessment of the coverage of the two legal challenges requesting judicial review and the independent chief inspectors of borders and immigration current review, the focus is quickly shifting to the assessment of Rwanda, not of the discriminatory policies at the heart of the externalization. Now, I spent today reading the Home Office's documents under review by the Chief Inspector, and the standard to be applied is that there is a real risk of the applicant being subject to torture or to inhumane or degrading treatment or punishment contrary to Article 3 of the ECHR. Now, the three flashpoints evident in these documents Rwanda are going to relate to the risk of persecution based on sexual orientation and gender identity and expression, the risk of arbitrary detention based on evidence in relation to the detention of political opposition and government critics in Rwanda, and Rwandan legal restrictions on refugees participating in political activities, particularly in relation to the murder of 12 refugees from the DRC in February 2018. Now, these are certainly valid critiques. My concern, and there will be extensive legal argument, as we have seen in the extradition cases around them. My concern here is that they shift too quickly from the policy of externalization itself towards Rwanda's safety or otherwise. The agreement is consistent from the Rwandan government's perspective in how they have tried to position themselves and leverage and use the carceral turn in border control to leverage powerful states. And so I'll finish here by just saying that I think it's important that we need to keep focus on those powerful states while also understanding the agency objectives, networks, and responsibilities of those with less geopolitical clout.
Thank you so much, Nikki. And you've provided a really good segue into the second half of the event, which is that our position as academics means that we can draw these deeper, broader geographical and historical connections to look at the issues of externalization and the implications for refugee convention broader than simply attacking a country like Rwanda. So on that note, I'm going to pass on to our third speaker, which is Asylum Shelali. Asylum is a PhD fellow at the Danish Institute for International Studies and the Department for Politics and Society at the University of Aalborg. She explores how externalization of European border control to North Africa produces the everyday violence of the border and how this shapes gendered experiences. So I'll pass back to you now.
Thank you, Vicky, and I hope you can hear me clearly. And also, I'm trying to share a screen. I hope that's working out well. Thank you so much for organizing this and also for my co-speakers as well. I mean, with this presentation, I would like to contextualize the proposals and the ongoing externalization efforts in North Africa from both an EU but also a Danish perspective, and look at the justifications and some of the consequences. So for years, the Danish government, long before Rwanda was on the table, were very explicit about making North Africa a potential host region for asylum camps outside of Europe. And this is linked to the fact that in the last decade, and especially since 2015, there has been this narrative that the EU has lost control over the union borders, and nothing has contributed more to that narrative than migration from and through North Africa. So this has, of course, supplied the pretext for what has, in fact, been not only a continuous intensification of militarized control of the southern border, but also an offshoring or an outsourcing of border control into North Africa. And the externalization here to third countries has become one of the central pillars of European Union's migration policy. I won't go into details, but since the 90s, EU has sought to outsource to third countries to prevent irregular migration, including asylum seekers from reaching EU territory. And this has especially been true for the Maghreb countries. And since then, we have seen a massive acceleration taking place. And as a consequence, we have also seen human rights organizations and the UN cataloging a spectrum of violence and human rights abuses in North Africa by states as well as non-state actors. And this has not prompted the EU to halt these externalization policies. On the contrary, the EU has been funneling millions of euros into North Africa, prompting a set of financial incentives created under the EU Emergency Trust Fund, including suggestions of opening migration reception centers, particularly in Morocco and Tunisia. This has, however, quickly been rejected by the Maghrebi states, as this idea has also long been resisted by countries in the global south and especially and particularly in North Africa. Member states then were pressing to get Morocco and Tunisia onto a list of these so-called safe third countries onto which to offload people seeking asylum. And here, Algeria, Morocco, and Tunisia were particularly targeted as potential countries to be listed, despite the concerning human rights situations that prevail in these countries. And I think, as Nick mentioned in the beginning, the use of the notion of safe countries has serious consequences for the rights of asylum seekers, and also expedited examination of applications, non-suspensive appeals are likely to be rejected, and also asylum applications cannot be used in countries where there's no asylum laws. So the fragility of the rule of law in the Maghreb countries does not guarantee the rights of people within their jurisdiction, and numerous rights violations are regularly reported by international organizations and civil society. Additionally to that, there is no asylum legislation or refugee status in Morocco or Tunisia, and no person in need of international protection can have their situation investigated by an institution with national competence. And furthermore, we have seen mass arrests by law enforcement, forced displacement, detention of migrants, even when in a regular situation, and also these collective expulsions are on the rise, especially in Morocco and Algeria. So while the number of people arriving on EU shores each year have decreased, we already see very poor protection standards for migrants and asylum seekers only being further exacerbated. To take the case of Morocco and Tunisia, their asylum systems have remained largely unreformed and outdated, and offer very little structural legal protection to migrants and asylum seekers. And the border control policies of both countries have been pushed and implemented with very low regard for the rights of migrants and refugees, which have led to violations of international refugee law and refugee protection standards. This has been documented on several occasions, recently also in Tunisia by the Tunisian security forces, pushing back migrants at the borders, but also detaining migrants in order to prevent them from making asylum claims. We have also seen several examples on how these partner countries, or EU partner countries as they are referred to, like Morocco or Tunisia, increasingly using migration as leverage in controlling the flow of migrants towards the EU, and this is really how we've seen this becoming part of geopolitical power plays. Recently, we've seen it on several occasions in Morocco, and recently also Spain expressing support for Morocco's autonomy proposals in Western Sahara. So this is, of course, not something new. It goes back to Ben Ali, the former dictator in Tunisia, and also Gaddafi in Libya. But essentially, migrants and asylum seekers end up as bargaining chips and are taken hostage in the political power games played out between EU and their so-called migration partners. And in this case, EU externalization means internalization of partner countries' political agendas. So I would like to look at some of these justifications that both the Danish proposal, but also the UK proposal, as well as the whole border externalization plan, is that this has been framed as a humanitarian approach with the aim to disrupt migrant smuggling networks. And this stands in very stark contrast with existing academic research on migration dynamics and smuggling, which have shown that smuggling networks have close ties to authorities responsible for migration control. And also this has also been documented by UN reports that smuggling networks are inseparable from local authorities. We've seen it very clearly in the case of Libya with the Libyan Coast Guards and Libyan smuggling networks, and similar cases have taken place in Morocco and Tunisia and Niger. So this one-sided focus on smugglers in current European policy debates, and especially with these proposals, really overshadow how other actors conduct violence, abuse, and also shows that many studies show that the money spent on smuggling is often used to bribe the authorities, and thus indirectly contributing to migrants' insecurity. So in Tunisia, for instance, I'm referring to Tunisia as I recently came back from fieldwork, but there is little indication there that irregular migration is rising due to the heightened availability of smugglers. Instead, there's a growing trend in Tunisia, what some have called as self-smuggling. I don't like the term myself, but it's basically Tunisians or people pooling their own money and going around these organized networks. So despite this, we have also seen in Tunisia more and more funds from Europe flowing into these so-called IBM projects, which are the integrated border management projects by several member states, both bilateral projects. Denmark has one cooperating with Austria in Tunisia, which are intended to seal off Tunisia's external borders, both the borders to Libya, borders to Algeria, but also especially the maritime border. And according to a recent report by the Tunisian human rights organization, Forum Tunisia pour les droits économiques et sociaux, the country has received more than 60 million euros since 2016 with the direct or indirect purpose of closing borders and reducing migration to Europe. And this is just an illustration of some of these projects. As you can see, there is all around the country, and the majority has been allocated to strengthen border patrol capacity, to train the Tunisian Coast Guard into what some have called the European Maritime Border Guard. And just for comparison, last year, 2021, we saw an increase in interceptions by the Tunisian Coast Guards. They intercepted up towards 24,000 interceptions, which was double the number of 2020 and almost an exponential increase over the last decade. And I think we will see much more of that in the future, and a new actor, not just the Libyan Coast Guard, but also now the Tunisian Coast Guard operating at sea. So another justification is that it saves lives, but again, in total numbers, the annual death toll has only been decreasing. However, has been argued that the rate of migrant deaths remains high, and that the risk that migrants face on their journeys have only decreased. So these ongoing externalization initiatives through North Africa especially, but also I think at the core of these proposals, both from Denmark and from UK, are, again, just to mention what Nick, I think also and Nicola mentioned, are ongoing efforts and not something new. And sum up, I think, would be there are still many unanswered questions in regards to also the Danish proposal, where that will be. But we do know that these externalization measures or migration regulatory efforts do have several unintended consequences. Many of them are already happening in North Africa as a consequence of the measures, and this obviously also perhaps something we can expect in Rwanda, including the acceptance of poor governance in the countries that we then depend on as our partners, a risk of strengthening these regimes and repressive forces, and also the fact that the prevalence of risk of trafficking, of violence, of more dangerous routes increasing. And then, of course, the establishment of migration partnership with countries that we do not necessarily work with, autocratic states in the Maghreb or fragmented states like in Libya, undermining the ability of refugees to receive the protection that they need. So I think with that, I'll finish here and be happy to take more questions afterwards. Thank you.
Thank you so much, Alan, for giving us a more detailed understanding of the broader context of border externalization into North Africa, which flowed so neatly from Nicola's earlier critique of some of the early responses to the UK and Danish Rwanda deals. Really interesting, and thank you. And yes, we'll have time for for questions after our last presentation, which is following the path towards giving the broader context within these debates. So I'll pass on now to our fourth and final speaker, Dr. Maya Niesner, who is a postdoctoral research fellow in modern slavery and human rights at the Bonnevier Institute for Human Rights here at Oxford, and a fellow of the Modern Slavery Policy and Evidence Centre. Her research focuses on trafficking for labour exploitation and the regulation of labour migration. And she has recently written a really interesting blog for border criminologies, as have a lot of the other speakers, which I'd really recommend to everyone in attendance. And she'll speak today on lessons from the Israeli experience. Thanks.
Thank you, Vicky, and thank you for including me in this important discussion. Can you hear me okay? Okay. Yeah. So I'm going to talk about the deportation of asylum seekers from Israel to Rwanda, a policy that is luckily no longer enforced, but offers some important lessons for some of the challenges expected in the UK. And I'm going to focus on legal and political responses to understand this policy. Some context of the Israeli situation is needed. So for a few years in the late 2000s, Israel has seen increasing flows of asylum seekers, mostly from Eritrea and Sudan. The Israeli response, very much like the policy in the UK over the last decade, was one of hostility, including explicit intention to deter further migration and to encourage the departure of those already in the country. Deportation to the countries of origin was not possible as the risks there were recognized by the government. So Israel adopted a very narrow understanding of protection that was offered little beyond non-refoulement. It abstained from recognizing people as refugees, granting instead temporary visas renewable for a few months that granted very limited set of rights. It also adopted various other measures reflecting a very strong understanding of temporariness of the stay and aim to encourage departure by all means necessary. Measures adopted against asylum seekers, including the prolonged detention in a facility in the desert under the infiltration law and its different amendments. It also included what was known as the deposit law, deducting 20% of asylum seekers' salaries as economic means of coercion, also to encourage departure. For the Israeli government, it was not very important where people go to as long as they go. So some asylum seekers managed to get relocation to countries in the global north with relevant programs, such as Sweden and Canada, but the numbers going there were not large enough, the speed not fast enough for the government. Around 2014, secret agreements were signed with third countries to accept asylum seekers from Israel. And while the identities of these countries was not officially disclosed, we've known for years, the countries were Rwanda and Uganda. I'm going to focus on Rwanda today for our topic. It was also the more important one. And the secrecy of these deportation agreements was presented as a condition imposed by the state of destination, so by Rwanda. The plan of deportation, the deportation policy to Rwanda faced legal challenges, and eventually it reached the Supreme Court. And like what the Supreme Court did in its judgment on this case, I'm going to address two main points concerning the deportation to Rwanda. First, the risks resulting from the deportation and the lack of guaranteed status after deportation. And second, the coercive nature of the deportation. So I mentioned the agreements were secret and many things were not known about the agreement with Rwanda. This was one of the key problems flagged by civil society, that secret agreements are hard to monitor and to enforce. It's hard to expect accountability and compliance when everything is conducted in conditions of secrecy. It's very difficult, if not impossible, for people to know what their rights are and claim them and demand them. And it's hard to assess risks to specific, in general, or to specific population when the destination is not disclosed and monitoring or means to ensure compliance, for example, through legal channels, are not effective. But still there were evidence gathered by civil society organizations and evidence based on affidavits and testimonies of asylum seekers deported from Israel to Rwanda suggested that such deportation might result in significant risks, including trafficking, exploitation, and smuggling. And I'm highlighting these risks because they're important in the UK context, as the UK government's rhetoric, and we heard it earlier, to justify deportation to Rwanda was as a measure that will help prevent trafficking and smuggling. And it's important to note that while there is no or very little evidence to actually achieve this claimed positive result, there is clear evidence to the contrary. So, like the claims now made in the UK context, the Israeli plan was accompanied by promises of protection in Rwanda, access to the asylum mechanism, housing and support for vulnerable migrants. The exact status and protection offered was always vague, with no explicit guarantees regarding refugee status and residence period, and the language used by the state was instead very broad language on possibility to live in dignity, opportunity to gain living by employment, and an undetermined period of stay, indicating long period, but never quite saying that. As the agreement was kept secret and formal statements did not even disclose that Rwanda is going to be the state of destination, information regarding these safeguards in reality was hard to obtain. Nonetheless, strong evidence refuted the promises of protection and asylum. People testified that upon arrival, asylum seekers were held in a guarded hotel. They were not allowed to leave. They had their documents taken, either for a short or long time. They were denied legal status. They were subject to arrests due to the lack of legal status, despite the promises given by the state to them personally and expressed in legal proceedings. They were not allowed to work in Rwanda. They were told they will not be allowed to work in Rwanda. And people testified they were told they will have no status in Rwanda and they should leave. Some people faced threats. Some had their phones taken shortly after arrival, therefore having limited means to communicate their situation. Some had their money given to them by the Israeli government before departure, taken from them shortly after arriving to Rwanda. And almost all of them had to leave Rwanda and travel to other countries, relying on smugglers and crossing borders illegally. Many encountered abuse, torture, exploitation, and trafficking as a direct result of their deportation to an unsafe situation. Important to note that in Israel, the Supreme Court rejected most of the evidence that I just described, and it rejected it generally based on secret material submitted by the government. So it's difficult to assess how convincing it was, but it is very questionable. The court did not rule out deportation to a third country. It did not reject deportation specifically to Rwanda. It did not reject doing so through secret agreements. It expressed some reluctance, but it did not reject this plan. What the court did reject was the pretense that any of this can be described as voluntary departure. And this is important. Until 2014, Israel generally framed its third country arrangements as voluntary departure. The voluntary nature of this departure was always questionable, and in 2015, the government abandoned it altogether, adopting a new policy of indefinite detention of asylum seekers, refusing to leave to third countries. This was part of the arrangement with Rwanda, and it's important to note that consent of asylum seekers was a condition Rwanda imposed for its agreement to admit asylum seekers. And one of the key claims discussed by the court, the only claim accepted by the Supreme Court in a very problematic judgment, was that detaining people until they agree to be deported does not reflect free or informed consent. And the court accepted this claim. It argued that coerced deportation can be acceptable, it just cannot be called voluntary return. This was the finding that failed the deportation policy for the first time, as it was not possible to continue with this policy without consent, and this was just not to be the case. Following this judgment, Israel sought a way to deport asylum seekers to Rwanda without their consent. And in 2017, another secret agreement with Rwanda was signed. And this time it was an agreement that Israeli official claimed that allowed forced deportation, a claim that, by the way, Rwandan officials denied. And if in the first round of campaigns against the deportation, the important response was the legal challenge through the courts, here in the second, the new arrangement, the forced arrangement, a key element was civil society response in political campaigns, addressing decision makers in Israel, but also in Rwanda through protests aimed at embassies around the world, especially in Europe, through public calls and media campaigns. And in April 2018, possibly due to this pressure on Rwanda to not accept asylum seekers forced to leave Israel, it was announced by the Israeli government that this agreement, assuming it was at any point what the Israeli government claimed it to be, whatever it was no longer valid, and forced deportation to Rwanda was not possible at the time. So a few lessons here. First, it's another example for how bad migration policies are replicated, demonstrating the needs for civil society, for researchers and activists to cooperate globally, noting that borders might block people, but bad policy ideas travel just fine. Second, it's important, I think, in terms of strategy, and this is, again, something that could be true for migration policy in general, that framing matters and strategy matters. And there's a question of whether the main challenge when considered such a new policy is a legal challenge or a political challenge, and what strategy should follow. So this is important. Last, and this might be the most important aspect and links to some of the things that Nicola said earlier and some other things suggested earlier, is that activists and researchers, we often frame such policies as focusing on one country, but these are inherently bilateral agreements and should be considered as bilateral. There are significant power gaps between global North and global South in terms of pressure and demands and conditions. But it's important to remember that the host country or the country sending refugees away, it's not the only actor, it's not the only one acting with agency or in a way that reflects its interest and incentives. And in the case of the civil society campaign facing Rwanda and putting pressure in terms of foreign relations there, it mattered, and it's something that could lead to change on both sides. And I think I will end here, and thank you.
Thanks, Mayan. I think I completely agree. It's a useful and important point to end on, just looking at who has agency in these bilateral agreements. So thank you. And thank you to all four of our speakers, Nicola, Alan, and Mayan, and again to Ida and Samuel for co-organising this event. We've got about half an hour for questions, if we end around 7. So if you do have a question, please could you put up your hand and I'll come to you. Ruvi, you got in very quickly with a question on the chat, so I don't know whether you're still around and would like to say it out loud, otherwise I can read it for you. I'll stop the recording now as well.